Hey there, my name is Ruben Rojas. I'm an attorney in California, going over some old cases just to refresh and back up. Also, I figured this would be a good way for me to pay things forward. If you've seen my first video regarding torts, my second video regarding criminal law, and my third video concerning constitutional law, then you know that to an extent, this is a way for me to pay things forward. Just like when I was a brand new 1L law student, uh, I go over cases in the same way that I wish somebody had done for me, in the way that would allow me to see how the process of the thinking is expected of us as students, and in the way that you just don't see in law schools. If you were born in an environment that meant being around a lot of lawyers, then this stuff probably won't be so foreign to you. Like you've probably seen this growing up. And you've probably had discussions with family members regarding cases or like what the realities of the legal industry are like. If you didn't grow up around lawyers, this world is gonna be pretty foreign. Uh, and I guess my goal is just to kind of demystify some of this stuff. So today we're gonna be covering contract law. Now, you probably heard quite a bit about contracts as like the average person has heard the word contract, and we we think we know what it is. Most of us think we know what it is. Man, you're in for a surprise because it's everything you don't think that it is, and it's everything that you think it's not. So, man, yeah, you're in for a shock, okay? Now, once you actually start to understand like what a contract is, um, it's relatively intuitive, at least in the US. That should be more clear. Um, yeah, it will be relatively intuitive. You'll see. Things will start to make more sense later. All right. So the first case we're going to be going over is Lucy versus Zehmer. I don't. Maybe that's how you pronounce it. I'm not sure. Zehmer. I think as long as I don't say sinner, it should be okay, right? Okay. Yeah. So as you can see here, I am going over this case via Justia. You are, by the way, more than free and welcome to like go on their website and check this stuff out for yourself. That's kind of the whole point of the way that I'm doing this. That's why I'm not like going through a special casebook, or I didn't like create my own casebook where you have to like buy it. No. See, I'm not I'm not here to really teach you law per se on its own. Uh, my goal is more to teach you how to learn law. Does that make any sense? It's the easiest way for me to explain it, I think, is that old phrase, um, give a man a fish he can eat for a day, and teach him how to fish, you feed him for a lifetime. Yeah, that's good and all, but what about the man that's already hungry and it takes more than just a day to learn how to fish? Like sometimes you just need somebody to give you a fish first, then teach you how to fish. You need to start somewhere. So that's what this is. Um, Once you actually learn the process of going through a case, like, one of these older established cases, especially, reading new cases is relatively intuitive. Like you'll understand what you're looking for. You'll get a good idea of like how law as a system is structured. That is, by the way, supposed to be the basic goal of law school, is to give you enough foundation where you can learn how to do how to approach new cases as they come to you. Like they don't so much focus on teaching you what the law is, so much as how to understand the foundational structure of how law is written. and how it's formed and what sort of policy things we think about whenever we go through them. So my format, like I said, is a little different. Like law school, I think that teaching via the Socratic method is probably really the way to go. I don't get the sense that law schools generally teach via the Socratic method really in the way that like Socrates intended. See, Socrates was really a chaotic instructor. Like he was all 100% controlled chaos. If you ever read The Republic, which is like, from his students, what they teach you, you're supposed to think the exact opposite. You're not supposed to take that book literally. You're supposed to argue with yourself as you read it. Like that's that's how law works. You're supposed to argue with yourself as you read it. So again, this is what makes things a little different here because I'm not gonna do the pre-filtered. I'm not gonna do the pre-filtered. This is what this case is about. They found that, you know, XYZ, and they ruled that blah blah blah. That's teaching you the law. That's not teaching you how to learn law. So I'm gonna do something a lot more chaotic. If you've seen my first, second, and third videos, then you know what I'm talking about. Like I do edit a little bit, like if there's something really distracting going on and it's just not part of the video. But I leave in my ums and my uhs and my huh and what does this mean and I don't understand this, but like I'm gonna leave that in, which if you know lawyers, you know that that doesn't generally happen. Like we are perfectionists. We don't like to leave in any mistakes. It makes us look bad and we don't like it. But as a student, you have to be super comfortable with not being perfect all the time. And that's something we're not very good at portraying, unless you're actually in law school. When you're in law school, it's funny because they tell you very early, like you can't be ashamed of not knowing. You have to be, you have to really humble yourself, and you have to be very quick to say, I don't think I know what this means. Maybe I have an inkling of what it could mean, maybe, but I'm not real certain. So I'm gonna have to look it up. So you're gonna see that too. I'm gonna look up words that you might think that's a really obvious word. Like I know what this means. No, 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 no. And you would be so surprised. There was I don't remember by the way, that there's a case I believe I think it was an LA County case where the entire case for the most part was on the judge exploring the definition of the word and 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 where it's positioned and what it means when it's positioned at the beginning of the sentence, at the middle of the sentence, at the end of the sentence, after a verb, before a verb. Is there an adjective in like in that? Depending on where that was depending on the outcome of that case. Yeah. And there's, I think, I don't even remember how many distinct definitions there is to the word the, the. Yeah, should look that up sometime. I know there's more than 5, like 100% distinct definitions. And they matter. In context of law, they matter, especially if you're looking at cases that are old. Now, today we're looking at Lucy versus Zehmer. Let's see, what time frame was this? So this was in 54. Okay. One of the reasons why I'm doing this the way that I am, by the way, is because how we learn law hasn't really changed in over 100 years, really. I mean, and I just don't think that there's any reason why we can't just record the process. So, and really the first step is you need to see what's like going through a lawyer's mind as they're reading these cases. Like, like I said, it's controlled chaos is what it is. So if it looks chaotic to you, know that it was purposeful chaos. Okay. we're gonna get wild here. All right. Now, you should know this. Here we go. So anytime you look at a case, you should always be thinking in three perspectives. The perspective of the person that is doing the suing, the person who is being sued, and the perspective of the judge. In contract terms, excuse me, I'm going to correct myself there because contract terms is actually an actual like term. I don't want to, it's an actual thing. Okay. Regarding contracts, uh, the person that's doing the suing is called the plaintiff, and the person who's being sued is called the defendant. That's not that different from some other things, but yeah, okay. So, in terms of contracts, we have to be aware of what the plaintiff is asking for. Are they asking for the contract to be fulfilled? Or are they asking for the contract to be voided, essentially? And if I'm remembering, just like the little log in my head, if I'm remembering properly, nearly always the contract, the person who is suing wants the contract to be fulfilled because the defendant has breached, meaning they have violated the requirements, the things that they are required to do or to provide or to, sell or whatever. They have violated that, or at least that's what is being said. And so now the person who is suing wants that contract to be fulfilled. And so the defense, meaning the method of voiding or not making it required to have that contract be completed, is typically going to start by saying, hey, there's no contract here in existence. Like, it didn't exist. All the things that were required to happen in order for a contract to be formed did not occur. If they are, then there might be excuses or defenses, right? And those are things that we recognize as being reasons why, even if there was all the requirements in order for something to, for a situation to be a contract, that there's reasons why we would say we're not going to enforce it in this case, right? In this situation. So Lucy versus Zehmer is we're gonna start by talking about like what kinds of things are required in order for a contract to exist to begin with. Before we start talking about did they do what they needed to do, meaning the reciprocal side of the contract, we need to talk about like what sort of situations lead to a contract, like at all, right? And that's what Lucy versus Zehmer is one of these. Okay, so anytime you look at cases, you should always be aware of when it is happening. 54. The reason why I say this is because language was different back then than what it is now. The way that they talk was different. The way that they wrote was different. Words can change over time, and that's something important to pay attention to. But also, the mentality of the time frame affects policy, and what it is that we regard as being important. Like back in 54, for example, people, at least the reputation is, maybe I'm wrong, I don't know, but the reputation is that people really took the notion of like a handshake as being super important. Like in today's world, a handshake doesn't mean a whole lot of nothing, right? Yeah, we shook on it. Okay, but did you get it in writing? That's what they would say today. Back in 54, things were a little different. So that's where this comes from. And that's not to say that a contract can't be formed on a handshake. Okay? I don't want you to quote me on that one. But there are more requirements today in order for a let me rephrase that. There are more barriers on what things can be contracted on with a handshake today than what there used to be. All right. Okay. You should also always pay attention to like where it's happening, like where this case is occurring. Here, this particular case that we're looking at today occurred in Virginia. Now, I haven't looked to see if, by the way, I haven't looked to see if, like Lucy versus Zehmer went to the U.S. Supreme Court. This one is, at least this stage occurred in the Supreme Court of Virginia. So something important to think about too. And that's part of the reason also why I'm more focused on teaching you how to read the case and what you should be thinking as you read it versus this is a case you need to pay attention to and that's a case you need to pay attention to. Because in real life, when you have a situation, you need to be able to look at all of them. And that's not to say that, how do I say this? That's not to say that if you have a situation, you should be representing yourself, even though everyone does to an extent. How do I say this? It's like I said in a previous video. Every person in the US is their own lawyer. Regardless if they hire somebody or not, they are their own lawyer first. And the more you know about this foundational knowledge, the better you are at choosing a lawyer that's competent. If you don't have any sort of foundation for law, how do you choose a lawyer besides based on what kind of suit they wear or what the car that they drive looks like? Like, how do you know that's a good lawyer? You don't. I mean, I guess you can make a guess based on which firm they're working for. Maybe I guess that's an indicator, but I've seen lawyers at big firms that are okay, and I've seen lawyers at smaller firms that some of them are really good. So it's not really necessarily a sign. And the industry is shifting also, like especially with AI. Yeah, I get the feeling that in the future, bigger firms won't really be such a thing. The industry is becoming very specialized. And so there's probably just going to be a lot of very boutique, very specialized smaller firms. That's my guess. Let's see if I'm wrong, That could be. Maybe I just don't know what I'm talking about. It's possible. So the if you have some sort of a foundation for law, it will help you to first identify if the lawyer that you're talking to is the right kind of lawyer for you, first of all, But also it helps you to identify what kind of lawyer you should be talking to. Because in every situation, there might be crossover, meaning you might need a lawyer that does employment law and a different lawyer that does personal injury for the same situation. Just imagine you get somebody who slips and falls at work, and then they get fired, and later on it comes to find out that they were also discriminated for for being too old and they got fired or something. you're gonna need more than one lawyer for that, probably, unless one lawyer does both forms of law, both practices of law. And so having some sort of foundation helps. It helps a lot. Uh, if you come across a situation and in explaining your circumstance to your attorney, you hire an attorney, they are supposed to help to identify some of that stuff, but they don't always catch it, you know? Um, like, or maybe they just don't think it's a big enough deal based on how the community, how the situation was explained to them. They might not really like, it might not click. Um, so again, having that foundation helps everybody actually to identify, okay, these things happened in my life. I might need a lawyer for this. And I have personally seen where, yeah, like a loved one thought that, they didn't have any sort of claim. And even talking to the lawyer, they didn't think that they had any sort of claim. And I ended up having to look into it and say, hey, did you look at these cases? And lo and behold, I guess they had something, So it's terrible to say that should be something that's needed, but it does happen. And look, there's a reason why um, even people who are born and raised into money, who they don't uh, they don't have any intention of becoming a lawyer, they still send their children to law school. Think about that. Yeah. All right. So that's part of the reason why I'm going to show you like all three perspectives. Okay. All right. Here we go. So, Supreme Court of Virginia, November the 27th. Whoa, I'm already messing this up. November the 22nd, 1954. A.S. Harrison Jr. and Emerson D. Baugh for the appellant. Now, okay, let me start here. Normally, I would start at the opinion. You see how it says opinion here? Like normally, the opinion, it begins really when a judge or a justice starts talking. And the stuff before that is the facts of the case. I made the mistake in the last case of saying, you should always look at the opinion first and then reverse engineer and then look at the facts to see how the judge or justice came up with this decision based on the facts. And in most cases that I've looked at, granted, I haven't been practicing for, like 50 years. That is the easiest way to like learn this case, right? Or any case. That said, the last case that I looked at, which was a constitutional law case, was painfully long in the opinion, and the facts were actually relatively short. If the facts are relatively short, go ahead and look at them first, and then look at the opinion. Normally it's the other way around. Like the opinion is like, maybe a quarter of the length, and then the facts are super long. They're like, this happened and that happened, and then this is what we came up with. Like that's normally, at least how I've seen it, that's normally how it goes. But not in that case. And it looks like not so much in this case either. Like the facts in this one, they actually don't even say anything about facts. It's just this website. And again, you can go to law.justia.com cases Virginia Supreme Court. Like you can look this up, right? Lucy Fisher Center. And then this is the other piece of the case name, right? 196 VA for Virginia 493, right? You can look this up and it'll take you to this. It doesn't even have a facts section. It just has opinion. Okay. Now, another thing to note is if you are a law student, I would 100% suggest looking at professional summaries. They help a lot. I used Quimby. I don't think I would have made it through law school without Quimby. Being completely honest, I don't think I would have graduated. For one thing, some cases are just so long, and you just don't have time to like really dive deep into everything, especially if you have other like personal or professional responsibilities you have to take up, on top of it. Because law school is super demanding. They give you a bunch of cases, and you have to be done by like 2 days later, end of the week, that kind of thing, right? You just don't always have that much time. And again, that's part of the reason why I'm doing this, because it gives you some insight on how to do this relatively quickly and like um, okay. And also the one thing is that the summaries don't give you really like all the perspectives in the way that you would see it as it occurs. It is clean, thank goodness. And they're usually like 10-15 minutes or something like that. you know like I said, I know Quimby does them. uh Maybe Justia does too. I'm not sure. I haven't really looked into them before. One of the main reasons why I went to Justia, by the way, is because they're like open. Like you don't have to pay to look at their stuff. So anybody watching this can go on their website and can go look through the cases they have on there. So yeah, I 100% recommend it, especially if you're not in law school, and you're just curious about like how these things look. Go do it. Do it. All right, here we go. Okay, right. So in this particular situation, this is what I was getting at. Because it's relatively short, like it starts right here, and then the rest of the case is the opinion. We're gonna look at the facts first because it's just gonna save us a lot of trouble. Okay. All right. So this is yeah. Okay. Here we go. In suit brought by Lucy against Zehmer and his wife for specific performance of a contract requiring the latter to convey a farm to Lucy for a stated price, the evidence contradicted Zehmer's contention that he was too drunk to make a valid contract, since he clearly was able to comprehend the nature and the consequence of the instrument he executed. So I mean, like, this is what I'm talking about. Like, they give you both the facts and basically the reasoning in one. You almost don't even need to read the case to know what it's about at this point. This is not, by the way, how most cases in most case books are written. Normally, they make you like, whew, they make you hunt for them. You have to like look at the details. But this is typically like one of the first cases, if not the first, that you see in contract law. So they kind of spell it out for you. Okay, all right. So whenever you're reading this is normally, by the way, something that would be in the opinion. This is like almost, and this is what I'm saying. Like, go look at the opinion first, and then go look at the facts. Which actually, this is in the opinion section because there is no facts section in this case. So they would have this, and then it would say, we find that he was not too drunk because he clearly was able to comprehend the nature of the consequences of the instrument he executed. So you look at that, and then after reading the opinion, you go look at the facts, and then you look to see all the things that the court saw, or rather, all the things that the plaintiff and the defendant presented to the court and said, well, this happened, and then that happened, and then you take those little pieces of information that they gave you, and then you put it in the little boxes. Like, okay, this shows that that they comprehended the nature and consequence of the instrument, and maybe nature and consequence are separate boxes. I don't know. We'll have to look at the case. Or they did not. On the other hand, they did not comprehend it, right? Or they comprehended the nature but not the consequence, or I don't know if you can comprehend a consequence and not comprehend a nature, but that's how you would look at it, right? So that would be like the starting the opinion, starting with the opinion gives you a bird's eye view of what the judge is thinking before the plaintiff and the defendant present their little pieces of evidence. Okay, so the judge is supposed to be the neutral third party that is uninterested in the outcome of the case. So they're there to represent the voice of reason. And in the world of law school, at least, judges are never wrong, and neither are facts. So that's what you're going to go off of, unless the instructor like actually says this is wrong and is incorrect. Assume that it is correct, and even then, I'd be a little skeptical about writing in a law school exam that this is not how it is. You would say something more like, this is how it is. This is how it should be. If your instructor said this is wrong, if they specifically said this is wrong, that's how you would address that. Okay. Yeah. Another thing, by the way, while we're on this topic of like addressing things that are disputed, if you will, some instructors will tell you that you should assume that one of the parties may be either giving incorrect information or they may be lying, that kind of thing, right? Which in the real world definitely can happen. Like, people don't always tell the truth in the real world, right? In the context, but in the context of a law school exam, assume that everything that you're being told is 100% true, even if the instructor tells you not to assume that everything that they say is 100% true. Like, they might even say in the instructions, you should assume that not everything that is being said is 100% true. That's probably not, unless it's like criminal law, maybe like some criminal law stuff, or maybe some evidentiary stuff. Okay. But every other case, you should just assume that if they said he was too drunk to make a valid contract, right? Then you should assume at least that he believes that he was too drunk to make a contract. You can make that distinction, right? Because the court, at least so far, even just based on this, the court says he was not too drunk to be able to comprehend the nature and consequences. So you got to be able to make that distinction, and your instructor will love you for that, especially because you have a very limited amount of time to say stuff. So, get to the point, but if you can make that distinction, right? Okay. All right. Here we go. Why does this keep popping up? I know I keep clicking, but okay, here we go. Okay. 2. There was no merit to the defendant's position that the instrument sought to be enforced was signed in jest and not intended by either party to be a binding contract. The appearance and terms of the contract and the circumstances of its execution indicated clearly that the transaction was one of serious business. All right. And yeah, you'll see later in one of the later cases that if one party was making like it was just a joke and it was never meant to be taken seriously, then there's no deal, right? Like, there's no, like, if anybody looking at this from the outside saw that this transaction was going on, like, if I was to say, for example, if you give me $1, I'll make you the King of England. Like, I don't have the power to make you the King of England, number one. And if I did, you can be rest assured that I charge you more than $1, right? That's a joke. Like, for anyone watching this, if you don't know this, that was a joke, okay? Which would be the same in this situation. Like, it would be a joke. That's how the court would look at it. Okay. And that's if you were to try to like sue me for not making you the King of England and you gave me $1. All right, here we go. Okay. Even if defendants entered into a contract in jest, they were bound to it since Lucy believed from the acts and statements of the Zehmers that, Zehmers was warranted in believing that the contract represented a serious and good faith sale and purchase. Mental assent is not essential for the formation of a contract. Interesting. Okay, we'll look at that later. But yeah, and that does change later on. But okay, for right this point, mental assent is not essential for the formation of a contract. Okay, that's definitely going to change later. I'll tell you that much right now. But okay. If the words and acts of a party reasonably interpreted manifest to an intention to agree, his contrary but unexpected state of mind is immaterial. Okay, all right. Specific performance is not a matter of absolute right, but rests in the sound judicial discretion. Yet, where in the instant case, there is no circumstance of there's no circumstance of fraud, misrepresentation, sharp dealing or other inequity, specific performance should be ordered. Specific performance, by the way, for those that are unfamiliar with the legal industry, which I know I certainly was whenever I was reading this, specific performance is when a court makes an order saying you will do this or you will not do this, right? It is most often appropriate when it comes to the sale of land or the sale of something that is unique, like a piece of artwork, right? Like selling a piece of artwork, or maybe even a collector's like one of kind of thing, right? If it can be replaced, then more than likely specific performance will not be deemed as being appropriate. And normally in that case, then it would just be money damages, right? So if the contract says that a I don't know $70,000 truck was the sale of the contract, then the money's worth of the truck would be just like returned, or that would be handed over, right? It wouldn't be necessarily for that specific truck, unless there was something unique about it, like actually truly unique. If, for example, that truck in this particular example that we're doing here, if it got repainted by like an artisan painter that did everything by hand, okay, now it's like become unique. It's become a piece of artwork at that point. So that would be something different. But if we're just talking about like a truck that they took off of the Chevy dealership, there's nothing like real crazy about it, right? So that's and those are points to look at, right? Okay. All right. So Justice Buchanan delivered the opinion of the court. This suit was instituted by W.O. Lucy and J.C. Lucy complainants against A.H. Zehmer and I.D.A. S. Zehmer, his wife, defendants, into the specific performance of a contract by which it was alleged by the Zehmers to be sold, alleged that the Zehmers had sold to W.O. Lucy a tract of land owned by A.H. Zehmer, okay, in Dinwiddie County. Dinwiddie? If you know how to pronounce that correctly, let me know. All right. Dinwiddie. Containing 471.6 acres, more or less known as the Ferguson Farm for $50,000. W.C. Lucy, the other complainant, is a brother of W.O. Lucy, to whom W.O. Lucy transferred a half interest in his alleged purchase. The instrument sought to be enforced was written by A.H. Zehmer on December 20th, 1952, in these words: "We hereby agree to sell to W.O. Lucy the Ferguson Farm complete for $50,000, title satisfactory to buyer, and signed by the defendants A.H. Zehmer and I.D.A.S. Zehmer." Okay, so the Zehmers signed this super specific, like this property for this amount at this location, like it's identifiable, and that is actually, by the way, something that would be important. Um, Now, I am curious to know who wrote it. You know, because depending on who wrote it, will depend on who it's construed against, which is a big deal, right? But it's definitive. We don't we're not talking about who wrote it just yet, but and that might not in this case because it might not be something that got brought up. It looks like right now it was only brought up, at least based on this, that it was a joke. And when it comes to either claims or defenses, the only ones that get the only ones that are considered are the ones that people bring up. So if they don't say, I didn't write that, the other person wrote it, and it should be. If they don't talk about that, then it's not something you would talk about in a case. This is just something that I would be thinking about. For example, if somebody came to my office and said, "Hey, this situation happened," I would be looking at that. I would be thinking, okay, well, who wrote it? I mean, yes, it was signed, yes, but that is something to look at. And again, in this case, it is super specific. So who wrote it might not be as much of an issue. But like, for example, if I remember, it's been years since the last time like this, but if I remember, like, the amount might be something that I'd be looking at. Like, I'm sure if the farm was being sold for $5 million, like, we wouldn't be, they probably wouldn't be complaining about it, right? Like, um, let me rephrase that. The sellers wouldn't wouldn't be upset about letting it go if it was being sold for 10 times, 100 times the amount. So these things are relevant, and they're, as a defense, they're almost saying that the buyers took advantage of the situation. So depending on who wrote it depends on who has the power over what's specifically being said on the contract. And one of the ways that someone can take advantage of the situation is by writing the agreement, the memorialization of the agreement in a way that is to their advantage, where the other person might not detect it. So that's why who wrote it is something that you should be looking at, or that's something that people should pay attention to. Now, I mean, we live in an age where we sign contracts all the time, and we sign so many of them that you like, we can't keep up with all of them, frankly. Anytime you go on a website, you're signing a contract. Yes, I agree to be on this website. No, don't sell my information. That's part of it. Like, that's, you're agreeing to something. So the fact that, in that example of, do not sell my information, if there was to be a lawsuit over the contract that is being agreed to whenever you are either selling or not selling your information, for example, the courts would look to see who wrote it, who had the power when this agreement was either when this agreement was being allegedly agreed to. And in the case of, the websites, it would be the person who made the website. Like, they wrote it, they have the power. No, you could have said no and left. That's true, maybe. I don't know. But the way that it's done matters. Yeah, it really matters. Especially in the context of, like, privacy law and stuff. But we're not going to get into that here. Just contracts is what we're talking about. Okay. Okay. The instrument sought to be enforced was written by A.H. Zehmer. Oh, here we go. Okay, so it was written by him, which means the court's not going to have much mercy against him, because they're going to say, we're going to construe this, we're going to view this through the lens of, you had the power to write this the way you wanted to, and you wrote it the way that you did. If the other side, if the Lucys had written it, they would be a lot more forgiving of the Zehmers. Yeah, they would be a lot more forgiving of the Zehmers if the Lucys had written the contract. But, okay. It wrote, we hereby agree to sell W.O. Lucy the Ferguson farm complete for $50,000, title satisfactory to buyer, and signed by the defendants. So I mean, like, man, if this was a joke, like, anybody seeing this or listening to like a conversation that led to it would not think that it was a joke. And that is something, by the way, that, if I remember, it's been a while, but that's what they're going to be looking at, is like, anybody looking at this would, you can say it's a joke, but we can't tell that it's a joke because this seems legit. Now, I don't know how much 50,000 was back in '54, but yeah, they would be looking at that too. Again, the farm isn't being sold for $1, and it's not being sold for 50 billion either. It's being sold for 50,000, which, all right, now I want to know. Okay, let's see. Let's see. Inflation calculator. Yay. In 54. So I mean, that's like 600K today. Now, I don't know if it's hard to say, really, because I don't know too many places today that you can buy 500 acres for 600 grand. That's why I'm not really like a huge fan of inflation calculators generally, because they don't account for buying power. They only account really for like inflation, like official of inflation. But still, 600 grand is like, it's not a trivial amount of money, right? Again, it's not $1, it's not 5 billion, right? It's an amount that sounds reasonable for what's being purchased. Okay. We'll get into like, other things later, like peppercorn theory and stuff like that, but it is important. Okay. The answer of H. Zehmer admitted that at the time mentioned, W.O. Lucy offered him 50,000 cash for the farm, but that he, Zehmer, considered that the offer was made in jest. In so thinking, that both he and Lucy having had several drinks, he wrote out the memorandum quoted above and induced his wife to sign it. Can you imagine? Okay, this is me just getting sidetracked, but because you already know, just based on the facts that they had up above, like, the Zemmers lost the case, meaning they lost the farm. Can you imagine how angry his wife is gonna be at him? Oh no. I don't mean to laugh about somebody losing a case, but convincing your wife to sign a contract that means losing the farm. I mean, granted, they got $50,000, but yeah, that's not gonna. My guess is she didn't take that well, even if they got money in their pockets. If for another reason, because if it makes you feel dumb afterwards for thinking that wasn't gonna go any further, but. And even on top of it, like that could be, I don't know how long the farm's been in their family line, but like losing your farm in your family line, even if you got the monetary equivalent for it, is, I mean, it's a big deal. Like, and that's, by the way, speaking of that right now, that is one of the primary reasons why specific performance is a remedy that is often used and made available for real estate stuff because it is unique. You know, like two properties that might cost the same amount might not, likely will not have the same value to the same person even. And so that's why specific performance is often um, a remedy that's used for real estate stuff. Like they would rather have the property than have the money. And if you really look at any sale, like um, if you look at any sale objectively, that's always what it is. Um, where the seller always would rather have the money than to have the property, whether it's a tangible item or whether that's real estate, and where the buyer has places more value on whatever it is that's being sold than the amount of money that it takes to get it. So, it's something to look at. Okay. Uh, 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 uh. Okay. That he did not deliver the memorandum to Lucy, but that Lucy picked it up, read it, put it in his pocket, attempted to offer Zehmer $5 to bind the bargain. So it was like a deposit. Okay, $5 deposit. Which Zehmer refused to accept, and realizing for the first time that Lucy was serious, so he realized it right then and there, okay? Zehmer assured him that he had no intention of selling the farm and that the whole matter was a joke. Lucy left the premises, insisting that he had purchased the farm. Okay, so yeah, they're just like, too late, bud. Like I got this piece of paper. It's got your signatures on it. Like it's mine now. And they're saying that the deal's done. We already finished it, so you can't no take backsies, right? That's basically like what they're saying. As a matter of contract. Okay. Depositions were taken, and the decree appealed from was entered holding that the complaints had failed to establish the right to specific performance and dismissing their bill. The assignment of error to this action of the court. Is to this action of the court. Yeah, okay. W.O. Lucy, a lumberman and farmer, thus testified in substance. He had known Zehmer for 15 to 20 years and had been familiar with the Ferguson farm for 10 years. 7 or 8 years ago, he had offered Zehmer $20,000 for the farm, which Zehmer had accepted. But the agreement was verbal and Zehmer backed out. Okay, so like this had already happened once before and it was verbal and he backed out. So something to look at here. Okay, something to look at here. And this is what they were talking about earlier. Zehmer had reason to believe that Lucy was not joking about this because he's already offered it once. For 20,000 at that, not 50. Like, what 50 is what 250% more. If I'm doing the math in my head right, yeah, that sounds right. So that means like Lucy really wanted that farm, and Zehmer really did not want to let it go, at least not for that amount. And this is, I don't know if they're going to talk about it in this case, but when there is contracts made for land, because they are so valuable in like which specific piece of land and like for how much, there's something we call the statute of frauds, which requires us to have all pieces of land all contracts for pieces of land be made in writing. There's more requirements than that, but that's, like if you say, hey, we had a contract and there was no writing for it, then like forget about it. You already lost, And so that's what they're talking about. It was verbal, right? So handshakes don't work when it comes to land. Okay. So Zehmer backed out. Okay. On the night of December the 20th, 1952, around 8 o'clock, he took an employee to McKinney, where Zehmer lived and operated a restaurant. filling station and motor court, where he decided to see Zehmer and again try to buy the Ferguson farm. Okay, so this is attempt number 2 now. Okay, yeah. He entered the restaurant and talked to Mrs. Zehmer until Zehmer walked in or came in. He asked Zehmer if he had sold the Ferguson farm. So yeah, I mean, like, they kept talking about this. Like, this is not new for Zehmer, right? Zehmer replied that he had not. Lucy said, "I bet you wouldn't take $50,000 for that place." Okay. Okay. All right. So I mean, if you're Zehmer, this is kind of the point. Like, and this is what they're talking about. Like, I thought it was a joke. Okay. Hearing it the way that he said it, I bet you wouldn't take 50,000 for that place. It's almost like daring him, right? Like, you wouldn't do it. Yeah, you ain't got the balls. You ain't gonna do it. It's almost like doing that, right? And I don't know if maybe Zehmer is like a descendant of like Marty McFly, but maybe he can't take you. You can't do it. What are you checking? Maybe he can't take that. I don't know. But so Zehmer, now he's saying, well, you know what? I thought it was a joke because you said I bet you wouldn't take 50,000 for that place. Not, hey, I really want to buy that place. I'd be willing to pay 50,000 for it. Like it almost, it does sound serious and it doesn't at the same time, and that's kind of the point, right? Okay, and it's not. This is kind of the point. It's not unforeseeable for somebody to pay $50,000 for it. At least based on this, I bet you wouldn't take 50,000 for that place. It's almost like I said, almost like a dare, right? And then Zehmer said, Zehmer replied, "Yes, I would too. You wouldn't give 50." So now he's like daring him back. He's like, "Yeah, I would take 50 for that, but I bet you ain't got the cash." Lucy said he would, and Zehmer, and then told Zehmer to write up an agreement to that effect. Okay, they're like, "Yeah, I'll do it. Write it right now. Watch me pay 50,000 for this place. Watch me." Zehmer took a restaurant check and wrote on the back of it, "I do hereby agree to sell W.O. Lucy the Ferguson farm 50,000 complete." Okay. So this is what the court was looking at. Now, this is my point about like the plaintiff. Think about this, right? Like the plaintiff, the defendant, and separately the judge. To an extent, the role of a judge is to decide in a way in which it makes an example out of people. Here, in this particular case, there may have been an element where maybe the judge wanted to make an example out of these two and say, don't waste my time with jokes. If you don't want to sell your farm, then don't joke about selling your farm. And, and I know that sounds really bad. Like if you're watching this and you're thinking, man, these judges are messed up, I wouldn't blame you for thinking that. But we also have to consider the reality that like government operates on limited funding and courts tend to be pretty overloaded. Like there's, grievances all the time. People have disagreements and, they want to go to court for it, which is where they should go if they can't come to a resolution on their own. But this is almost like a court's way of saying, don't manufacture problems. Like if there's a genuine dispute, cool. All right, we'll work through it. But you knew that this buyer was serious. Serious about wanting to buy the farm, if nothing else. And they were willing to pay real money for it. So don't invite conflict. Okay? So that's a perspective that they're going to be thinking. Maybe that's not the primary reason why they went this way, but it's something that they probably had in the back of their mind, right? Okay. So Lucy told him he had better change it to the we because Mrs. Zehmer would have to sign it too. So he's like making this more and more formal, right? Like he's like, yeah, we got to think about the legal stuff too, right? Zehmer then tore up what he had written, wrote the agreement quoted above, and asked Mrs. Zehmer, who was at the other end of the counter, 10 or 12 feet away, to sign it. Mrs. Zehmer said that she would for 50,000 and signed it. Okay, all right, yeah, yeah. And again, I don't know if this is a joke. Like her response, I mean, I don't know if her response is like, yeah, for 50,000. This is one of the things that I'm not like a huge fan of with reading court cases. Like the tone of voice that people use is different, right? Like, and to an extent, that's why we do trials in person, so that you can like see what kind of body language somebody has whenever they say something. What's the tone of voice, that kind of thing. But like reading this, I don't know how she said it, and that is relevant, you know. So we have to trust that the jury was able to pick up on their testimonies to see if she was, when she said it, it sounded like a joke, or when she said it sounded serious. The unfortunate part is that people don't always replicate their emotions when they're doing their testimony, especially if they had been like reviewing it with their lawyer many times, and you really see that. You probably really see that with like domestic violence cases, as tragic as they are, where excuse me, where all the emotional temperature is still present the first time that somebody is recounting events. But if they've had to recount the same events, 15 times, because each different person wants you to retell the story whenever they're filling in their end of the paperwork, by the time you get to court and you're retelling these things, like you might not, the victim may not have the same emotional response as when they first said it. Obviously the paperwork is important, but it's something to consider. Especially if the person, when they're recounting events, they seem a little too calm. I would say don't assume don't assume that it means that they're lying, or that it didn't really happen because it looks so calm. It might just be that they've just had to retell the same story 15, 20 times, for their lawyer and for the police and for this and for that. Like, and that's just an example, obviously. But yeah, the way she said it, we can't know. There's no way for us to know, right? But yeah, for 50,000, I'll do that. Shoot, right? You never know. That's what they're talking about, and that's kind of the point, right? And maybe another thing, and maybe this is something that's mentioned. Maybe it's not something that is mentioned. Maybe Zehmer, knowing his wife, knows that she would never agree to $50,000 to let go of the farm, because maybe it's like a prized possession to them. I don't know. And again, that's the point. Or maybe he doesn't. I don't know. But that's the point. Like, and there's some things that you just wouldn't know. And so, to an extent, the courts don't want to spend a bunch of time trying to guess what's in people's heads. And so that's part of the reason that they're looking at this the way that they are, because they can only go based on what actually happened, not just what you were thinking. Not all the time. Like there would be a lot of resources that would have to be invested into trying to figure out what people were thinking, and we don't want to have to do that all the time. So, don't joke about selling your farm. At least that's what this is saying, right? Okay. Okay. Zehmer brought it back up, gave it to Lucy, who offered him $5, which Zehmer refused, saying, "You don't need to give me any money. You got the agreement there signed by both of us." All right. Oh man, I keep doing this. The discussion leading to the signing of the agreement, said Lucy, lasted 30 or 40 minutes, during which Zehmer seemed to doubt that Lucy could raise $50,000. Okay. So it's like this negotiations occurring, and they're like, yeah, the only thing that's holding me back from making this transaction go through is I don't think you got the cash. Okay. Lucy suggested the provision for having the title examined, and Zehmer made the suggestion that he would sell it complete, everything right there. It stated that all he had to do, that all he had on the farm was three heifers. Is that for like making bales of hay? I don't know. Let me see. I don't know how healthy a heifer is. A young female cow that has not yet given birth to a calf. Okay, that is not what I thought it was going to be. This is what I'm talking about. Like, is that correct? Oh my goodness. Yeah, I would have never guessed that. Yeah. Okay, cool. I mean, not really important in like this particular circumstance, but good to know. Okay. Lucy took a partly filled bottle of whiskey into the restaurant with him for the purpose of giving Zehmer a drink if he wanted it. Zehmer did, and he and Lucy had one or two drinks together. Lucy said that while he had felt the drinks he had took, Lucy said that while he felt the drinks he took, he was not intoxicated, and from the way Zehmer handled the transaction, he did not think he was either. Okay. So he's not even claiming that he was intoxicated. Okay. All right. December 20th was on Saturday. Next day, Lucy telephoned to JC Lucy and arranged with the latter to take half the interest in the purchase and pay half of the consideration. On Monday, he engaged with an attorney to examine the title. The attorney reported favorably on December 31st, and on January the 2nd, Lucy wrote Zehmer stating that the title was satisfactory. So I mean, like Lucy like took steps, like he's really taking this very seriously. Lucy telephoned JC Lucy. Arranged for that later. Yeah. Okay. And the attorney, yeah, okay. And he was ready to pay the purchase price in cash and asking whether Zehmer would be ready to close the deal. Zehmer replied by letter mailed January the 13th asserting that he had never agreed and intended to sell. Okay. So he was what we call repudiating, meaning that he was like backing out of the deal, right? Or rather he was saying, hey, there was no deal ever. So he wasn't even repudiating, he just wasn't making, there was never a deal. Like we were never serious about this. And maybe this is where we talk about like, who sees what, stuff like that, right? Maybe in Zehmer's mind, maybe just, he was just so tired of like Lucy's like, I want to buy this piece of property that he was just like saying, okay, you know what? Let's just pretend like we are just to shut you up. Maybe it'll just make you feel better. Maybe that's what it was. Who knows? But the court doesn't like that. And that's the point, because they want people to take deals seriously. So that's where we're at. Okay. Mr. and Mrs. Zehmer were called by the complainants as adverse witnesses. Zehmer testified in substance as follows. He bought this farm more than 10 years ago for $11,000. He had 25 offers more or less to buy it, including several from Lucy. Yeah. Who had never offered any specific sum of money. Okay, let's backtrack here a little bit. He bought this farm more than 10 years ago for $11,000. He had 25 offers more or less to buy it, including several from Lucy, who had never offered any specific sum of money. He had given them all the same answer, that he was not interested in selling it. On this Saturday night before Christmas, it looked like everybody and his brother came there to have a drink. He took a good many drinks during the afternoon and had a pint of his own. When he entered the restaurant around 8:30, Lucy was there and he could see that he was pretty high. Okay. He said to Lucy, "Boy, you got some good liquor drinking. Boy, you got some good liquor drinking, ain't you?" All right. I got to practice my cowboy voice. Lucy then offered him a drink. I was already high as a Georgia pine and didn't have any more better sense than to pour another great big slug out and gulp it down. And he took one too. After they had talked a while, Lucy asked whether he still had the Ferguson farm. He replied that he had not sold it, and Lucy said, "I bet you wouldn't take $50,000 for it." Zehmer asked him if he would give him $50,000, and Lucy said yes. Zehmer replied, "You haven't got $50,000 in cash." Lucy said he did, and Zehmer replied that he did not believe it. Okay, all right. So stories are slightly different, right? Like, okay. They both generally say the same thing, but there's some slight variance. They argued pro and con for a long while, mainly about whether he had 50,000 in cash and that he could put it up right then and buy that farm. Okay. And that he could put it up right then and buy that farm. Yeah, okay. Finally, said Zehmer, Lucy told him that if he didn't believe he had $50,000, you could sign that piece of paper here and say you will take $50,000 for the farm. He, Zehmer, just grabbed the back of a guest check there. Just grabbed the back off of a guest check there and wrote on the back of it. At that point in his testimony, Zehmer asked to see what he had written to see if I recognized my own handwriting. He was like, "Yeah, I was a little drunk. Let me see. Do I recognize my own handwriting? Yeah, it seemed like that looks like it's mine." Okay. He examined the paper and exclaimed, "Great balls of fire. I got Ferguson. Now, I got Ferguson for Ferguson. Ferguson. I got Ferguson for Ferguson." Okay. "I have got satisfactory spelled wrong. I don't recognize that writing. If I would see it, wouldn't know if it was mine." Okay. Okay. After Zehmer had, as he had described it, scribbled this thing off, Lucy said, "Get your wife to sign it." Zehmer walked over to where she was, and she at first refused to sign it, but did so after he told her he was just needling him, Lucy, and didn't mean a thing in the world that I was not selling the farm. Zehmer then took it back over there, and I was just looking at the darn thing. I had the drink right there in my hand, and I reached over to get a drink, and he said, "Let me see it." He reached and picked it up, and when I looked back again, he had it in his pocket, and he dropped a $5 bill there and said, "Here's $5 payment for it." I said, "Hell no. That is beer and liquor talking. I am not going to sell you the farm. I have told you that too many times before." Okay. Mrs. Zehmer testified that when Lucy came into the restaurant, he looked as if he had had a drink. When Zehmer came in, he took a drink out of the bottle and that Lucy handed to him. Okay. He went back to help the waitress who had been getting things ready for the next day. Lucy and Zehmer were talking, but she did not pay too much attention to what they were saying. She heard Lucy ask Zehmer if he had sold the Ferguson farm, and Lucy replied that he had not and did not want to sell it. Lucy said, "I bet you wouldn't take 50,000 cash for that farm." Zehmer replied, "You haven't got 50,000 cash." And Lucy said, "I can get it." Zehmer said he might form a company and get it. but you haven't got 50,000 cash to pay me tonight. Lucy asked if he would put it in writing that he would sell him this farm. Yeah, okay. Lucy asked him if he would put it in writing that he would sell him this farm. Zehmer then wrote the back of the pad, I agree to sell Ferguson Place to W.O. Lucy for 50,000 cash. Lucy said, all right, get your wife to sign it. Zehmer came back to where she was standing and said, you want to put your name on this? She said, no. But he said in an undertone, it is nothing but a joke. And she signed it. So part of the moral of the story here, ladies, is if your husband is selling his farm as a joke or selling his and your farm as a joke, don't listen to him. I guess. Not in that moment. Not when he's had some drinks. Don't do it. Yeah, all right. She said that there's only one paper was written, and it said, I hereby agree to sell, but I had been changed to we. However, she said that she read that she has signed what she has signed and was then asked, when you read, we hereby agree to sell to WTO Lucy. W.O. Lucy. WTO. Where did I get that T from? What did you interpret that to mean, that particular phrase? She said she had thought that it was a cash sale that night. But she had also said that when she read that part about title and satisfactory to buyer, she understood that if the title was good, Lucy would pay 50,000, but if the title was bad, he would have the right to reject it. And that was that was her understanding at the time she had signed her name. Okay. All right. On examination by her own counsel, she said that she said that her husband laid this piece of paper down after it was signed. That Lucy said to let him see it, took it, folded it, and put it in his wallet. Then said to Zehmer, let me give you $5. But Zehmer said, no, this is liquor talking. I don't want to sell the farm. I have told you that I want my son to have it. This is all a joke. Okay, so this is exactly what we're talking about here. Like he wants his son to inherit it. Maybe because that's where he grew up. I don't know. It's just like a family tradition kind of thing, right? Like no amount of money is enough for him, basically. Okay. Lucy then said at least twice, Zehmer, you have sold your farm. Okay. Lucy then said at least twice, Zehmer, you have sold your farm. Wheeled around and started for the door. He paused at the door and said, I will bring you $50,000 tomorrow. No, tomorrow is Sunday. I will bring it to you on Monday. I will bring it to you Monday. Okay. She said you could tell definitively that he was drinking, and she said to her husband, you should have taken him home. And he said, well, I'm just about as bad off as he is. So they were both messed up. Like, I don't know if they were stumbling or what, but you know. Yeah. and looking at this like right now, I wonder if Mrs. Lucy was looking at this thinking, man, that guy's so drunk. Like he thinks he bought a farm for 50 grand. What an idiot. Like, who knows, you know? But again, this is 56, and so, you know, drinking was like, you know, not that uncommon, I guess. I mean, it's not like, you know, back in the old West where, you know, drinking at work wasn't like unusual. But, you know, it's different from today. Like today we take the notion of like somebody was drinking real seriously, and, you know, we talk about like agreeing to stuff. And we examined that more than we did in 56, or was it 56 or 54? You know, the 50s, right? Like, let's see, was when did drinking and driving become illegal? Hey, yeah, perfect. 1911. So definitely still after 56, but you know, but that was 40 years away from back then, whereas now it's like over 100 years, at least in California. Let's see, 1910. By the late 30s, started to appear, and by the late 1880s, all 50 states had clear drinking and driving. So in the 50s, there might not even have been in Virginia. I don't know. There might not even have been like a strict drinking law against drinking and driving. So, I don't know. Let's see. In VA, Virginia. Oh, here you go. Assuming that this is correct, good old AI, you never know. In 1984 is when it passed its first like per se drinking bill. So at this time, you could have like if you can drink and drive, you can sign a document and drive, right? Or sign a document and drive. Drink and sign a document. I don't know. Maybe that's what the court was saying. You were drunk, but you weren't that drunk. You could have still driven. Maybe that's what it was. I don't know. Okay. The waitress referred to by Mrs. Zehmer testified that when Lucy first came in, he was mouthy. When Zehmer came in, they were laughing and joking, and she thought they took a drink or two. She was sweeping and cleaning up for the next day. She said she heard Lucy tell Zehmer, "I will give you so much for that farm, for the farm. I will give you so much for the farm." And Zehmer said, "You haven't got so much. You haven't got that much." Lucy answered, "Oh yes, I will give you that much." That almost sounds like flirting, man. I will give you my whole world. You got the whole world, give me. Oh yes, I do. And then they jotted down something on a paper, and Mrs. Lucy looked. Excuse me, and Mr. Lucy looked over and took it. Said, "Let me see it." He looked at it, put it in his pocket, and there's like four different stories of like how this all went down. There's like 3 or 4 different versions of this. Maybe that's why the court was like, man, nobody's got it straight. But at the end of the day, they all thought something serious happened. So, and maybe that's what we'll see later. Okay. He looked at it, put it in his pocket, and in about a minute, he left. She was asked whether she saw Lucy offer Zehmer any money, and replied, "He had $5 laying up there, but they didn't take it." She said Zehmer told Lucy he didn't want his money because he didn't have enough money to pay for his property and wasn't going to sell his farm. Both of them appeared to be drinking right much, she said. This was the waitress saying this, right? I think. Okay. She repeated on cross-examination that she was busy and paying no attention to what was going on. She was some distance away and did not see either of them sign the paper. She was asked whether she saw Zehmer put the agreement down on the table in front of Lucy, and her answer was this. Time he got through writing whatever was on the paper, Mr. Lucy reached over and said, "Let's see it." And he took it and put it in his pocket before showing it to Mrs. Zehmer. Her version was that Lucy kept raising his offer until he got to $50,000. Okay, so $20,000, $25,000, like an auction. I don't know. 50,000 reminds me of the Addams Family. Like, anytime I think about an auction now, I think about the Addams Family. I know, they're not related at all, but anyway. The defendant insists that the evidence was ample to support their contention that the writing sought to be enforced was prepared as a bluff or dare to force Lucy to admit that he did not have 50,000, that the whole matter was a joke. that the writing was not delivered to Lucy and no binding contract was ever made between the parties. Okay, so this is something actually kind of interesting to think about. Okay. Because and I don't think this case talks about it, but the joke on what in which direction. Because let's say for example, this is like, a very extreme example, but it should illustrate it. Okay, if I was to say, uh, I do a lot for $1 billion. Like I would sell my toenail clippings, right? My toenail clippings for $1 billion, and I would never, in fact, sell my toenail clippings to anybody because I just don't think they're worth anything, let alone $1 billion. And somebody came along and said, okay, here's $1 billion. Take these. I want those toenail clippings. They're mine now. Like they belong to me. When I made the offer, when I said I would sell this for this much, it was meant as a joke because I never thought anybody would take it up. And that's kind of what's going on here. Like, it was a joke to the extent that they never thought that he would actually find it to be that valuable. So $50,000 to them is a lot of money for the farm. Like in their perception, that farm is not worth $50,000. They wouldn't pay $50,000 for that farm. That's kind of the point, right? And so they think that because they wouldn't pay $50,000 for that farm, that no one else would pay $50,000 for that farm. Just like I think no one would pay, $1 billion for my toenail clippings. And boy, would I be surprised if somebody reaches out to me and gives me $1 billion for my toenail clippings. It would be like that, right? The bluff in the opposite direction, because this joke is a defense. That's what we talk about. Like, it's a formation. It's a formation defense. Like it was not meant to be taken seriously, right? That notion of a joke is normally done in the opposite direction, and that's when it would be sufficient. Okay. So if I said I will sell you the farm for $1, or in my case, if I made the offer that I would be somebody's employee for the rest of my life, that they pay me $1 a month, and then I said that was clearly a joke. Like I'm not gonna sell you all my services ever. I'm not gonna sell all my expertise and services for the rest of my life for the cost of $1. Like that was a joke. And it's in the defense that I would clearly never take it, and no one would ever make that same offer, right? Because in any part of the world, having somebody be your employee for the rest of their life for $1 is definitely worth the expense. Like, I don't think there's any part of the world that even like the most impoverished places where they work for less than $1 a year, for example. And I could be wrong, but certainly not for a lifetime, right? So to say that the joke was that the value was too high and that they wouldn't take it, it's something really it's like really something else entirely, right? Like the court would be more than likely far more understanding if the deal was for $1. Then they would have said, okay, yes, there's some injustice here. The deal was for $1. Like no one can be expected on the other side, the like a buyer, no buyer could reasonably think that you're going to sell them land for $1.
But a buyer could 100% reasonably believe that if you were to offer a price that is comparatively much higher than what is normal for that thing or that, service or whatever it is that they're buying, that the person might think to themselves, you know what, I normally wouldn't sell this. I normally wouldn't be willing to do that. I normally wouldn't do this or do that. But if you're offering that much, okay, you don't have to twist my arm too hard. Okay, all right, I'll do it. I'll do it. And that's kind of what's going on here, right? Like if anybody had the defense, if anybody had the claim that, you know what, this was just a joke, it would actually be Lucy, because he's offering more. He's offering 5 times more than what Zehmer paid for it. I think I said earlier that Zehmer paid $11,000 for it, and he's paying 50. And the amount that they're offering, uh, Zehmer doesn't believe that Lucy can come up with that amount. Like it's just such a high amount, you know. So it's a big deal. It's a big deal, right? To look at like what's going on here. Like who is the joke being played on is something that really should be of relevance. I don't remember if they actually looked at that specific implication, but the court definitely should be looking at that if they're not, And maybe that's something that we'll see in later cases. So let's keep going. Let's find out. Okay. Okay, that whole matter was a joke. That the writing was not delivered to Lucy and no binding contract was ever made between the parties. It is an unusual, if not bizarre, defense. When made to the writing admittedly prepared by one of the defendants and signed by both, clear evidence that is required to sustain it. In his testimony, Zehmer claimed that he was as high as a Georgia pine, and that the transaction was just a bunch of two doggone drunks bluffing to see who would talk the biggest and say the most. Okay. That claim is inconsistent with his attempt to testify in great detail as to what was said and what was done. Meaning he was maybe buzzed, but he wasn't so drunk that he don't remember what happened. And I guess in 54, that was the thing that we really, really looked at, right? So, okay. Okay. It is contradicted by the other evidence as to the condition of both parties and was rendered of no weight by the testimony of his wife that when Lucy left the restaurant, she suggested Zehmer drive him home, meaning he wasn't too drunk to drive. We went back to the drinking laws back then, so Okay. And if anything, she thought that Lucy was too drunk to safely drive home, but Zehmer wasn't. And Zehmer is the one that this contract is being enforced against. So, that's the relevance. The record is convincing that Zehmer was not intoxicated to the extent of being unable to comprehend the nature and consequences of the instrument he executed, and hence that instrument is not to be invalidated on that ground. Okay. So then they quoted contracts. Okay. It was in fact conceded by defendant's counsel in oral argument that under the evidence, Zehmer was not too drunk to make a valid contract. Oh man, that's, yeah. I mean, you lost now, right? Like that was, if anything, that was like his biggest defense. It's like, nah, he was too drunk to make a valid contract. But I mean, the lawyer said, nah, he wasn't too drunk to make a contract. So yeah. He lost any. That's what I'm saying. Like if you don't say like these are my defenses, this is what I'm asking for, then you're not gonna get it. So yeah. By the way, that could actually still be a tactic. If it is safe to concede something, so I don't want you to think that just because something was conceded that it was a bad idea. But if it's safe to concede something then there is a tactical approach in conceding what is safe to be conceded, because it doesn't harm you, and it is more trustworthy to be reasonable in conceding what you can concede, um, so that whenever you do argue something, it's not like the boy who cried wolf. Like if you're in court and you are um, arguing on every single little thing, then it's gonna make that party look like a petty person, or like a dishonorable person who won't take responsibility for anything. And especially juries, they're not gonna trust that person when it counts. So if you can safely concede on something that is not like a driving point in the case, then yeah, by all means, consider it from a tactical standpoint as to whether or not it's a good idea to do that. So maybe that's what happened here. Maybe that's why they conceded that. Okay. The evidence is convincing also that Zehmer wrote two agreements. The first being, I hereby agree to sell. Zehmer first said he could not remember about that, then said, I don't think I wrote but one out. Mrs. Zehmer said that he wrote, what he wrote was, I hereby agree, but that the I was changed to we after that night. The agreement was, excuse me, the agreement that was written and signed is in the record and indicates no such change. Neither are the mistakes and spelling that Zehmer sought to point out readily apparent. So I don't know if they're saying that they don't trust him. We'll take a look at that later. Okay. The appearance of the contract, the fact that it was under discussion for 40 minutes or more before it was signed. Okay. Yeah, that's actually like really, really important, because you have to kind of think it through, right? To talk about it for 40 minutes. Though people who are really, really drunk, boy, they can talk about the same thing over and over and over and over and not really be talking about anything for hours. So maybe that's not such a big point, but it's something that the courts looked at the time. Remember, this is 56. So, I guess they just expect you to hold your liquor more back then. Yeah. Okay. Lucy's objection to the first draft because it was written in the singular and he wanted Mrs. Zehmer to sign it also. The rewriting to meet the objection and the signing by Mrs. Zehmer. The discussion of what was to be included in the sale, the provision for the examination of the title, and the completeness of the instrument that was executed, the possession of it by Lucy with no request or suggestion by either of the defendants that he give it back, are facts which furnish persuasive evidence that the execution of the contract was a serious business transaction rather than a casual, jesting matter, as the defendants now contend. So this is, by the way, where the court said, your whole reason why you say we should throw this contract out, we're not buying it. Like, yeah. Okay. On Sunday, after the instrument was signed on Saturday night, there was a social gathering in a home in the town of McKinney, at which there were general comments that the sale had been made. So now it's become like a public thing. Like, people know. It's not just between them. Like, people know, right? Mrs. Zehmer testified that on that occasion that she passed by a group of people, including Lucy, who were talking about the transaction. $50,000 was mentioned, whereupon she stepped up and said, well, with the high-priced whiskey you were drinking last night, you should have paid more. That was cheap. Okay. So I guess they would have bought it if it was, they would have sold it if it was for more. At least Mrs. Lucy would have said that. Mrs. Zehmer. Lucy testified that at that time, Zehmer told him that he did not want to stick him or hold him to the agreement because he, Lucy, was too tight and didn't know what he was doing, to which Lucy replied that he was not too tight, that he had been stuck before and was going through with it. Who said this? Lucy testified that at the time Zehmer told him, okay, so Zehmer was like trying to like give him an out I guess, like, nah, man, you were too messed up. Like, nah, I ain't gonna hold you to 50 grand. Don't worry about it. And then Lucy was like, no, no, I'm good. I'm good, man. I'll pay it. Okay. Zehmer's version was that he said to Lucy, I am not trying to claim it wasn't a deal on the account of the fact the price was too low. Okay. So the price was good for him. He was good with that. Okay. If I had wanted to sell $50,000, if I had wanted to sell $50,000 would be a good price. In fact, I think you would get stuck at 50,000. So he thought it was a really good deal, right? A disinterested witness testified that what Zehmer said to Lucy was that he was going to let him up off the deal because he thought that he was too tight, didn't know what he was doing. Lucy said something to the effect that I have been stuck before and I will go through with it. Okay, all right. Just kind of repeating themselves. If it be assumed, contrary to what we think the evidence shows, if it be assumed, contrary to what we think the evidence shows, that Zehmer was jesting about selling his farm to Lucy and the transaction was intended by him to be a joke, nevertheless, the evidence shows that Lucy did not so understand it, but considered it to be a serious business transaction and the contract to be binding on the Zehmers as well as on himself. The very next day, he arranged with his brother to put up half the money and take half the interest in the land. The day after, he employed an attorney to examine the title. The next night, Tuesday, he was back in the Zehmer's place, and there, Zehmer told him for the first time, Lucy said that he wasn't going to sell, and he told Zehmer, you know you sold that place fair and square. After receiving the report from his attorney and the title was good, and he wrote to Zehmer that he was ready to close the deal. Not only did Lucy actually believe, but the evidence shows that he was warranted in believing that the contract represented a serious business transaction and a good faith sale, purchase of the farm. Good faith sale and purchase of the farm. In the field of contracts, oh, here we go. This is going to be important, I bet. In the field of contracts, as generally elsewhere, we must look to the outward expression of a person as manifesting his intention rather than to his secret and unexpressed intention. That is, by the way, if you're in 1L, if you're in your first year of law school and you're taking contracts and your instructor had you read this case, they just had you read this whole freaking case for these words right here. That's it. This is what you need to memorize. Got that? Memorize this. Memorize this. For your 1L contracts exam. Okay. Like really even specifically like this. And then at the end, so you're going to, whenever you come across somebody getting drunk and, well, it was a joke, you're going to write in the field of contracts as well as generally elsewhere, like verbatim, you want to write this, right? As generally elsewhere, we must look to the outward expression of a person as manifesting his intention rather than his secret and unexpressed intention. And then you put in brackets, Lucy. Or Lucy versus Zehmer. Yeah, that's what you want to do. Okay. Yeah, I don't know why. It took me quite a while for me to figure out, this is one of those, I feel like it should have not taken me so long to figure out that's what instructors wanted, but that's what they want. Okay, so yeah. Do that. And I can't promise you an A because I don't know how everybody else is going to do, but you'll do better than if you didn't know that. I can say that much at least. All right, here we go. The law imputes to a person an intention corresponding to the reasonable meaning of his words and acts. Okay, First National Bank, Ranaco Oil. Okay. So, and you can actually you can quote this too. If you can remember it and you have enough time to like write all this stuff down, because law school exams are timed. Yeah, you can write this, and I don't know for sure if there'll be extra points, but yeah, there might be. Okay. At no time prior to the execution of the contract had Zehmer indicated to Lucy by word or act that he was not in earnest about selling the farm. They had argued about it and discussed its terms, as Zehmer admitted, for a long time. Lucy testified that if there had been any jesting about it, Lucy justified that if there was any jesting, it was about paying $50,000 that night. Okay. The contract and the evidence show that he was not expected to pay money that night. Zehmer said that after the writing was signed, he laid it down on the counter in front of Lucy. Lucy said Zehmer handed it to him. In any event, there had been what appeared to be good faith offer and a good faith acceptance. These are, by the way, really, really important for you to know in anything contract related. Like during law school, during the bar, like there has to be an offer, there has to be an acceptance. If there isn't both, there's no contract. So memorize those two pieces. For there to be a contract, there's actually 4 pieces. It's an offer, a valid acceptance of that offer, consideration, which is we'll talk about that later. That's something that is being traded for that offer that is legally sufficient. Again, we'll talk about that later. And then defenses, and then in absence of any valid defenses, which a joke being a joke is a type of defense. So this was in part about an offer, but it was the examination of defense, especially the defense of it being a joke. And they said, well, doesn't seem like a joke to us, so not valid, right? Okay. But good faith offer, good faith acceptance, right? Okay. Followed by the execution and apparent delivery of a written contract. Both said that Lucy put the writing in his pocket and then offered Zehmer $5 to seal the bargain. Not until then, even under the defendant's evidence, was anything said or done to indicate the matter was a joke. Both the Zehmers indicated that when Zehmer asked his wife to sign, he whispered that it was a joke so Lucy wouldn't hear and that it was not intended that he should hear. Oh, so he said it was a joke, but he didn't want to let Lucy in on the joke. So he intended for Lucy to believe that it was real. Oh, yeah, that's a problem, huh? Yeah, okay. So don't let your husband sell the farm, and when he's drunk, and don't let him believe that a joke is not a joke whenever he's dealing with somebody else. Or don't let him make somebody else believe that a joke is not actually a joke when selling the farm. All right, here we go. Yeah. Mental assent of the parties is not a requisite for the formation of a contract. If the words or other acts of one of the parties have but one reasonable meaning, his undisclosed intention is immaterial except when an unreasonable meaning which he latches to his manifestations is known to the other party. Okay, so this is a restatement of the laws of contracts. And yeah, you should definitely know this, right? Mental assent of the parties is not requisite for formation of a contract. They're gonna end up changing this later, so I don't want you to focus too much on this particular thing, because they'll find that yes, it does actually need it. But yeah, this is where the reasonable and objective third party is coming into play. So it's less about what the two people are thinking. It's less about what somebody has in their head and more about what somebody looking at the situation would have thought as they were going through it. But even that too is going to be changed later. So, yeah. If you don't understand what you're agreeing to, you'll see later. Like if you don't understand what you were agreeing to, then there's no contract. But not what we're talking about here. So, okay. The law therefore judges an agreement between two persons exclusively from those expressions of their intentions which is communicated between them. Okay, clock on contracts. Yep. An agreement or a mutual assent is of course essential to a valid contract, but the law imputes to that person the intention corresponding with the reasonable meaning of his words and acts. Okay, that's what we're talking about here in this case, right? Okay, if his words and acts, judged by a reasonable standard, manifest an intention to agree, it is immaterial what may be real but unexpressed state of mind. Okay. So a person cannot set up what he was merely jesting when his conduct and words would warrant a reasonable person in believing that he intended a real agreement. Okay. Whether the writing signed by the defendants and now sought to be enforced by the complainants was the result of a serious offer by Lucy and a serious acceptance by the defendants, or was a serious offer by Lucy and an acceptance in secret jest by the defendants, in either event constituted a binding contract of sale between the parties. Okay, so this is where Zehmer doesn't like this, right? Okay. So right now we're only examining, at this point, we're only examining if there was a contract at all. We're not examining if there's any excuses. We're only just examining if there was any like if all the prerequisites, those four, like offer, whether there was an offer, we knew we're talking about a house, so there's an offer. There was an acceptance. Lucy said, "Yep, I'll do that." There was consideration, which was the $50,000 in exchange for the house, and it was legally sufficient. There's nobody arguing that it was not legally sufficient. Even Zehmer himself said, "Wow, I'm getting a freaking deal with this house," right? Or this farm, excuse me. And whether there was any legally valid defenses. And he's not calling for any legally valid defenses, except maybe a joke, which that's what they were really examining. And they said, well, it's a joke to you, but it wasn't a joke to the recipient. So, and no one, here's the important distinction, okay? As far as a joke is concerned, because later on you'll be looking at jokes and the person who is making the joke thought it was a joke, and the person who received the would-be offer didn't take it as a joke, but they should have taken it as a joke. Okay. And in this particular matter, this is what we're talking about, like $50,000 for that farm was a reasonable amount. So there's no reason for them to have thought that it wasn't a joke. Assume that it was a joke. Okay. Defendants contend further, however, that even though a contract was made, equity should decline to enforce it under the circumstances. These circumstances have been set forth in detail above. They discuss some drinking by the two parties, but not to an extent where they were unable to understand fully what they were doing. There is no fraud, no misrepresentation, no sharp practice, and no dealing between unequal parties. Okay, so that's apparently, if there was drinking, that's what we would be looking at. Okay, so yeah, pay attention to that. The farm had been bought for $11,000 and was assessed for a taxation of $6,300. The purchase price was $50,000. Zehmer admitted that it was a good price. We had just talked about this, okay? There was in fact present in this case none of the grounds usually argued against specific performance. So this is what I was saying, like you get what you ask for, or you can only get up to what you ask for. If you don't ask for any of the defenses against specific performance, you're not going to get them. We're just going to assume that you're okay with it. So, yeah. Specific performance, it is true, is not a matter of absolute or arbitrary right, but it is addressed to be the reasonable and sound discretion of the court. Okay, First National Bank, again, is what they were citing. But it is likewise true that the discretion which may be exercised is not arbitrary or a capricious one, and one which is controlled by the established doctrines and settled principles of equity. And generally, where a contract is in its nature and circumstances unobjectionable, it is as much a matter of course for courts of equity to decree a specific performance as it is for a court of law to give damages for breach of it. Okay, so they're saying, yeah, we can do that. The complainants are entitled to specific performance of the contract sued on. So this means that Lucy, because remember, he wants the farm. Lucy wants that farm, and he's willing to pay 50 grand for it. Like, he's willing to do that, even though it's not worth that much, but he's willing to pay that money. And so, and that's the point of all this, is he wants the farm more than he wants the money. So Lucy is a complainant. He's the plaintiff. And by winning his case, he is entitled to a specific performance, meaning that he is entitled to the completion of the transfer of the farm being from Zehmer's possession into being Lucy's possession. And basically, Zehmer, oh no, is going to be forced to accept the money. Yeah. Okay. The decree appealed from this is therefore reversed, and the cause is remanded for re-entry of a proper decree requiring the defense to perform the contract in accordance with the prayer of the bill. Reverse and remanded. Okay. So that's it. That is Lucy versus Zehmer. This is the first case, like I said, that I'm covering, at least on regarding contracts. So usually the first ones are, the longer ones. Like later on, they might be a little shorter. There are some cases that can get pretty long. So we'll see what the spacing is looking like as we move forward. Like I said, the facts are certainly shorter on this than what you would see on some other cases. Normally they're pretty long. Normally the facts are pretty long and the opinions are not as long. But here it's like 99% opinion and like 5% facts that are really more a summary of opinion, really. And I don't think they even call it opinion. Yeah, they didn't. They just called it. They didn't even call it facts. They just call it opinion, like from the get-go. So, all right, here we go. If you liked it, let me know. If you didn't like it, let me know. Tell me what you wish you had seen a little different, besides the length and maybe some of my tangents. Yeah, let's see how this all goes. See you next time. Bye.